I don't know. So does that show up for everybody?
Yes.
Okay.
Do you want to try to expand your screen to the full screen?
But she can start the slideshow.
If you do slideshow from beginning, it should fix that. Yeah.
Yeah.
Perfect.
I just didn't know if that would be easier, then you wouldn't have to, click.
No, I appreciate it. I think it's working well.
Good. I might have to hop off after my time. I'm happy to take questions after I go, but my family is trying to go out of town at 3 today. And I have just got a sort of client emergency that they want to talk to me about. Do you think that would be terrible if we did it that way? Since, I don't think Amy, I don't think your presentation and mine really overlap at all. So I think, if people have employment questions, they're going to know what they are when I'm done.
The participant ID.
And if they have other ones, I'm happy to have questions emailed.
Okay. I think, so what we can do is, we can kind of get in minutes after your talk and actually do Q&A then, related to, go ahead.
Okay.
Does that work, Lindsay?
I was just going to say, I think that participants are logging in right now. So.
Yeah. Okay. But just to confirm, would you be okay with kind of spending some time on the Q&A after your, okay, great.
Yes, absolutely.
All right. Well, then we will begin shortly. I'm going to mute my line and I'm going to just show a screen now. So if you could just.
I'm going to mute myself and turn off my video so it's not distracting while Lindsay's talking. And then when she leaves, I will come back. But I'm here.
Perfect.
What am I, do you want me to do anything since I'm sharing this presentation, or is that fine just to leave up until we?
I'm going to change what you're saying.
Oh, perfect.
Welcome everyone to the Small Business Town Hall. We will begin shortly. Welcome to the Small Business Town Hall. We'll begin shortly. Thank you for joining us. Welcome to the Small Business Town Hall. If you have questions for our panelists today, feel free to use the Q&A. Welcome to the Small Business Town Hall. We'll begin in about 4 minutes. Thank you for joining us. Hello and welcome. Thank you for joining our Hopkins Local Small Business webinar discussing legal considerations for reopening. We'll begin shortly. Hello and welcome. We will begin in approximately 3 minutes. Thank you for joining our webinar. Hello, thank you so much for joining the Hopkins Local Small Business webinar. We will begin in just 1 minute. Thank you for joining. Welcome, everyone. We are literally just seconds away from beginning. Thank you so much for joining our call today. Okay.
Hello and good afternoon. My name is Alicia Wilson. I'm Vice President for Economic Development for Johns Hopkins University and Johns Hopkins Health System. And it's my extreme pleasure to invite you and to welcome you to the HopkinsLocal Small Business Legal Webinar, Legal Considerations for Reopening. I know that as the state and Baltimore City continue to slowly reopen, many of you as business owners are seeking information regarding the legal questions that you may have, as well as your rights. This session is meant to allow for you to ask those questions and have them answered by two amazing women who are experts in their field that can provide that information. HopkinsLocal, I just want to give you some background. HopkinsLocal is Johns Hopkins University and Health System's commitment to buy, build, and hire in Baltimore City. Kylie Patterson, who is on this video as well, is our Director of Economic Inclusion and leads that work. Please visit our website at hopkinslocal.jhu.edu to learn more. This webinar is going to be about 90 minutes long. We know that there are legal questions regarding reopening, tenants' rights, employees, and customer relations. Please post your questions in the Q&A, and Kylie Patterson on the call will work to insert your questions into the conversation and or raise them during the question and answer section of the call. Finally, it's my pleasure to introduce our first speaker, Lindsey White. She is a partner at Shawe Rosenthal LLP. She will review important information regarding employee relations and for business owners. With that, I turn it over to you, Lindsey.
Thanks, Alicia, and thanks, Kylie, for organizing this. I'm very pleased to be here today presenting this to all of you, and as well as Amy, who follows. Alicia, Amy, and I all went to law school together, and Alicia and I were actually in the same small section. So it's really an honor to be here alongside of them, and I look forward to working with you. My law firm is a labor and employment boutique firm here in Baltimore. We represent employers of all sizes. We have clients that are Fortune 500 companies all the way to smaller businesses and in many industries such as the nonprofit sector, the for-profit sector. So we have been working since this pandemic started, have been working on this topic of what to do with COVID-19 in the workplace. It's a brave new world out there. So I am going to bear with me while I load my PowerPoint and get that going. Okay. So, and I believe you will all get a copy of this PowerPoint at some point today. At the very end, there are numerous links of resources for you. I try to include all of the current agency guidance from the CDC to OSHA to the EEOC. I know we have lots of acronyms in the employment context, but I really wanted that to be a resource for you. And then my contact information is here as well if anybody wants to reach out directly. You can also reach out and ask to be put on our mailing list. We send out email alerts. We do a monthly, essentially, e-newsletter as well as email blasts when there are really important developments. And there have been a lot of those in the past 3 months. So just send me an email and I'll make sure that you're added. Okay. So today I'm going to talk about CDC and OSHA guidance, waivers of liability, what to do with your employees who are at higher risk of severe illness. What about your employees who have caregiving responsibilities? We're going to talk about employee refusals to work. Hopefully you haven't had any of those yet. And then finally, I'll talk a little bit about reducing workforce and operations. And I saw some of the questions that were posed in advance, and I saw a couple of questions on the PPP. I don't know that we're going to have time to cover the PPP today specifically, which is, if you don't know, the Paycheck Protection Program, which is employers can apply for funding. Smaller businesses can apply for funding to cover payroll and then apply for full forgiveness. And there have been a lot of modifications, including a recent revised act that changed how those funds must be spent. So without further ado, let's get started. Okay, so when you are thinking about what you're going to do, whether, and I'm sure people on this call, some of you maybe have been operational the entire time, maybe in-person operations because maybe you're essential businesses. I know many of my clients have been, and then many clients have also been working remotely. And then some clients and businesses have been shut down because they couldn't operate safely. So I know that everybody's probably in a different spot as to where they are in this process, but I wanted to talk about the most up-to-date guidance from the CDC. The CDC has a very helpful document about reopening, office reopenings that I'd really encourage everyone to take a look at. They have it's maybe about 30 pages, or actually this is an OSHA guidance on returning to work. But the CDC is, of course, the definitive authority. So all the other federal agencies and the state agencies that are looking at reopening are taking their cues from the CDC. So with that, so keep that in mind. And the CDC has a lot of great resources about returning to office buildings. OSHA has that guidance on returning to work that I mentioned. Both agencies have issued a lot of guidance. OSHA has industry-specific guidance. In fact, so many different types of specific guidance that I did not even think that I could list it on the PowerPoint in the resources. So OSHA has come out with the 3 phases of reopening. And of course, I believe all of you are in Maryland. We are largely in phase 1. We're largely in phase 2. Baltimore City is maybe still in phase 1. Baltimore City and some other jurisdictions have lagged behind a little bit. But for OSHA, phase 1 is telework when possible, limit numbers of those in the workplace, accommodate high-risk employees, which we'll talk about in a minute, and limit business travel. Phase 2 is continue to telework when possible, but plan for a reopening. And this is really where I think we are. And I think this correlates in large part to the Maryland, recovery plan, which is also a 3-part plan. So easing numbers, limitations of numbers of those in the workplace, but maintaining that social distancing, continue accommodations for high-risk employees and those with high-risk household members. And I'm going to talk about all of this from an ADA perspective, Americans with Disabilities Act perspective, in a little bit. And starting to resume some limited non-essential travel. And then phase 3, which is a little optimistic, back to normal. We don't know when normal is going to be. That's why this is the new normal. So as you consider reopening, or maybe as you consider what you're doing in your operations, you want to look to a workplace health and safety plan. You want it to be, every workplace is different. Your job functions are different. Your physical layout is different. What might work for one won't work for another. But you want to take an inventory of your specific workplace and identify all areas and job tasks with potential exposure to COVID-19, and then think about measures that you can take to eliminate or reduce exposure. So some of these tasks are, if you don't own your building, will be done in connection with property managers, landlords, etc. But you want to make sure you have ventilation. You want to maximize circulation. Check for other hazards that you might have. And with that, you can conduct a hazard assessment to determine when, where, and how exposure to COVID-19 might occur. Now, maybe there are some people on the phone who are healthcare workers or experts. I'm certainly not. This pandemic has forced a lot of people to learn a lot about a disease that they may not normally know, but what we do know is that it's spread through respiratory droplets. So, think about that. The CDC defines close contact as within 6 feet of somebody who's infected for 15 or more minutes. So I think if you consider that that's the benchmark, you can also then structure your return to work in a way that minimizes those things. You can utilize masks, which we'll talk about later in the presentation. You can do social distancing. Can people stay in their own offices? If you're not set up where people have an office, can you install plexiglass in between cubicles to reduce the spread of droplets? Some employers are making their walkways one way, so to reduce people passing each other in the hallway. Elevators have a limited capacity. So these are all types of things you might want to start thinking about. And then establishing a communication plan to prevent transmission is very important. If you're going to require masks in the workplace, you really want to make sure people know how to wear it, take care of it. And then you want to think about what you're going to do when you have an outbreak, or not necessarily an outbreak, but when somebody tests positive or has symptoms. Here are some other considerations. Nothing here is really earth-shattering. It's, just common sense, practical things that you can do to minimize risk. You can also implement administrative controls, such as sick leave policies if you don't have one. And everybody should have one, because here in Maryland, you're required to offer paid sick leave if you have more than 15 employees. And if you have fewer than 15, it's unpaid sick leave, up to 40 hours. Or 40 hours is what you have to offer. So that was a 2018 law. So everybody should have some policy like that in place. And you may also fall under the Families First Corona Response Act protections, which I'll get to shortly. Some other things that you might want to consider is a daily symptom and temperature screening, staggering shifts and break times, conducting virtual meetings. I have a client that has 7 employees that are coming back to the physical office, and they are not going to be meeting in the conference room. They're going to be meeting through Zoom, even though everyone's, in the same physical location. Now, I recognize that depending on what kind of, work you perform, that may or may not be realistic, but, there are certainly things that you can think about. Here are some other things. Cleaning, whether it's going to be people internally or, your cleaning company that you have for your office, or maybe your property manager has that. You can certainly talk to a property manager and landlord to see what it is that they're doing. So visitors, limiting or prohibiting visitors. If you are a retail operation, you're not going to want to, because that's how you make your money. So you're not going to limit those folks, but some other companies may do well to limit visitors for now. You can also screen your visitors. You can require them to answer the same questions that you would of your employees to make sure that nobody's coming into your workforce or to your place of employment with symptoms or who has tested positive. Obviously, here in Maryland, in retail operations, customers have to wear masks. You can require your visitors to wear masks. There's nothing that prevents that. You can temperature screen your visitors. You can require social distancing, okay? And then, the CDC has a lot of very helpful resources about educating your supervisors and employees about measures that they can take. There are lots of posters that you can print out and put in your break room, and resources about how to wear a mask properly, hand hygiene. It's, that's the comment that I made. It's, disturbing that you can't buy soap anywhere, because what were people doing before? Were people just not washing their hands? I don't know, but people are now washing their hands a lot, and it seems kind of like a basic thing that you teach children to do, but it's all of a sudden, something that's still helpful to remind people, okay, you need to wash your hands for 20 seconds with soap and water, and etc. So screening, let's talk about screening for a little bit. So the EEOC has and if anybody here doesn't know, this is the disadvantage of not being in person, because, it's kind of difficult to see if people have questions as we go. But the EEOC is the governmental agency that enforces anti-discrimination laws. So here, the obvious one is protections for people with disabilities. And the EEOC also prohibits unlawful medical inquiries. So pretty early in the pandemic, the EEOC came out and said that it is okay to ask screening questions about symptoms. And even though it's a medical inquiry, it is a medical inquiry that is warranted in light of COVID-19. So OSHA and CDC recommend screening. EEOC says it's fine. So you may ask your screening questions. And generally what people are doing is doing a temperature check, asking about exposure. Have you been in close contact with anybody who has tested positive or who has symptoms within a certain time period? Asking the employee or the visitor if they themselves have any symptoms, and telling people that they can't come to work if they have symptoms or if they've been exposed. You need to know that the list of symptoms has expanded over the past few months. At first, we thought it was solely a respiratory issue, but now there are gastrointestinal problems. There's something called COVID toe, which looks, I don't know if you've seen the pictures, it looks pretty horrifying. There are loss of sense and smell and taste, which are unusual, but are now considered hallmark symptoms of this illness. So just make sure that if you're going to screen, which I do think you should, that you're keeping on top of new symptoms as the CDC announces them. And know that, plenty of people have COVID and never have a fever. So there's only, you can only screen for so much. OSHA does recommend having employees screen at home to avoid spread in the workplace. I think in some regard that can work, but also a lot of clients are screening people before they enter the building. And I think that's a good alternative as well. If you're going to screen, there are a lot of things to keep in mind. Who's going to be the temperature taker? I mean, ideally, you're going to have if you're screening temperatures in the workplace, you're going to have an infrared scanner where you can stand away. You want that person to wear PPE and be trained. Another alternative is there are staffing agencies or other companies that will come on site and do the screening. That may be cost prohibitive, but that is an option. If you record results if you record employees' symptoms and their temperature, you need to treat that as a confidential medical record. And hopefully everybody knows this, but under EEOC laws, you must keep a personnel file segregated from an employee's medical file. So any kind of medical related paperwork, doctor's notes, FMLA, an ADA accommodation, all needs to be in its own separate file. Okay, believe it or not, OSHA says that if you're going to record, oops, sorry, I didn't mean to just jump ahead. OSHA says if you're going to take down this information, you have to keep it for 30 years. So it's a extreme record keeping obligation. The other issue is it compensable time while employees are waiting to be screened? And the answer to that is it depends. And if the time is de minimis, which means very little, then it would not typically be compensable. But if you have, a line of 40 employees standing 6 feet apart and, you go one by one, you kind of have to, you just have to look at it with respect to the facts and circumstances of your workplace. All right, so OSHA and the EEOC have said that you as employers may implement worksite COVID-19 testing. So, whether or not you choose to do that is within your discretion, but there are employers who are doing that. There are outside companies that will come and do that, obviously, because COVID right now is done through a nasal swab. You're not going to be able to administer that test on your own. So that is that's the status of testing. Testing is still not 100% reliable. The results are, it still varies, but it varies on the side of there tend to be more false negatives than false positives. Okay, antibody testing. This was a hot topic. Everybody wants to do antibody testing because they think if I know that somebody's already had it, then I can proceed accordingly in the workplace and we don't have to worry as much. And I completely get the appeal, but one, the CDC and the EEOC say that you cannot require this of your employees. It is an unlawful. Unlike testing for the presence of COVID, antibody testing is an unlawful medical inquiry. And also, these tests have not been validated by the FDA, and we don't know from the scientific community whether or not antibodies confer immunity. I mean, we all assume that it's going to confer immunity just based on the fact that most viruses, once you have them, you do receive some immunity. But so that's the status of antibody testing. So let's talk about PPE for a few minutes. That is personal protective equipment, which is required by an employer to protect the employee from workplace hazards. And as you are evaluating whether you're going to require this, you would go through this, and this is all from OSHA, a hazard assessment through a hierarchy of controls before you require the PPE. So there was a lot of discussion and debate about whether cloth face coverings are PPE or not, because if something's PPE, then there are certain requirements under OSHA for employers to follow. Cloth face coverings, so what most people are wearing right now out and about, are not PPE. And that's because they don't really protect the person wearing the mask. They protect your respiratory droplets from getting out to others. So because of this, employers are not required to pay for them. There might be some states, I think everyone here is Maryland based. There might be some other states that require that, but Maryland does not. And you might wish to provide them just, as a benefit, but you're not required to. So again, here in Maryland, in the retail setting, everybody, folks need to wear these. Others can choose to. What I'm recommending for my office clients is if you have individual offices and your employee is working in an individual office, they don't need to wear a mask when they're sitting there. But employees should wear masks whenever they're in public spaces, coming and leaving, using the restroom, using the break room, that type of thing. And you can also choose to require your visitors to wear them. If somebody has an issue that prevents the use of a covering, you must engage in a reasonable accommodation discussion under the ADA. The most common one I've seen is people who are deaf or hard of hearing because they rely on their, well, that might be for other employees in the workplace, but they rely on reading lips sometimes. So that's one instance. And you don't want to require a face covering if it somehow poses a hazard to the operation of your workplace. And that would, I believe, would mostly be in like a manufacturing type context. So surgical masks are medical devices, but they're not respirators. And again, like the cloth mask, they prevent the spread of droplets. They cannot protect against airborne infectious agents, but may protect against splashes and sprays. So they're kind of a hybrid. They can be PPE in one sense, depending on how you're using them. If you're using them for a different reason, they might not be PPP. So, and the reason this matters is if something is considered PPE, then the employer must provide it. And then finally, respirators, including those N95, those are those are PPE. And if they're required for a particular job, OSHA has a respiratory protection standard, and that would apply. And you have to have a respiratory protection program and, follow those rules. So illness at work. What happens if if an employee becomes ill at work? They need to immediately isolate and leave, clean and disinfect the employee's work areas. I recommend everybody call the local health department for guidance. They can be very helpful in working through exactly what should happen. And then you also want to do some contact tracing and notify any other employees who might have been exposed. So that would
Lindsey,
be, yes.
Quick question from the audience. If someone is not feeling well and you send them home, are you required to pay them for that day of work?
So that's an excellent question. And I hate this answer, but it somewhat depends. I mean, you always have to pay somebody for whatever hours they've worked. I mean, if they're hourly, you need to pay them for the hours worked. If they're salaried, they can use salaried or really exempt from overtime. They can use sick leave to get paid for what they miss. But if somebody who's exempt has worked any part of the day, you need to pay them for the day. But in terms of what I think the question is really, which is if somebody feels ill, and I'm going to say that I'm changing the question to they have symptoms of COVID and they are seeking testing. That is something that would be covered under the new law, the FFCRA, which is Families First Corona Response Act. And I have slides that address that in just a couple of minutes. So I think that once we get there, that will make that very clear. And then if it doesn't, we can take that question further.
Great, thank you.
Sure. So with contact tracing, you want to figure out who the employee has been in close contact with. And that's within the 48 hours prior to development of symptoms or a positive test. And then you want to notify those employees that they've potentially been exposed. You do not tell them who the employee is that's infected. You do not ever want to disclose that. And then depending on what kind of industry you are, if your employee has been exposed, they need to either self-quarantine if you are a non-essential business. Self-quarantine means go home for 14 days, or if you are essential, the employee may continue to work as long as they're asymptomatic. They may continue to work, but they need to self-monitor and have some additional protocols, like they have to wear masks, observe social distancing, that kind of thing. So returning to work after somebody has had COVID, when can people return to work? Well, there are two protocols according to the CDC. One is symptom-based. You can do, someone can return to work safely 10 days since symptoms first appeared, respiratory symptoms have improved, and they've been 3 days fever-free without medication. Or there's the test-based protocol. The first two are the same, but then 2 negative tests at least 24 hours apart. You can also require a fitness for duty note from your employees, with just being mindful of the fact that it might be difficult for them to obtain that. Okay, some more OSHA information. COVID-19 is an OSHA reportable event if the infection is work-related. So if it was work-related and involves medical treatment beyond first aid or days away from work, must be logged on those two forms. And how is something work-related, you might ask? Well, OSHA has a great guidance document that says especially small employers should not undertake extensive medical inquiries, but you should ask your employee how he believes he contracted the illness, while respecting the employee's privacy, and review the work environment for potential exposure. So I'm sure you've all seen the news articles about the meat factories that have had these huge outbreaks. Okay, well, if somebody works at one of those facilities, 30 people came down with COVID, let's say, it's pretty clear that that's a work-related transmission. But if somebody comes to you and they said, look, my wife had COVID and now I've tested positive, pretty clear that it was not through the workplace. And that only has to do with, whether or not this needs to be reported to OSHA, okay? So waivers of liability, switching gears, they are not enforceable for your employees. So there is no point in you doing this. You cannot, employees can never waive away certain rights like workers' compensation, which they could be entitled to if they contract COVID in the workplace. And some states, not Maryland, but maybe Maryland will, some states are saying, if you're working and you get COVID, we're assuming for workers' comp purposes that you got it in your workplace. Waivers of liability, however, may be useful for visitors and customers. You really need to think about, and this is less of a legal consideration and more of a practical one, what are your PR concerns with it? I mean, what are your competitors doing? I know I'm preparing to send my children to summer camp, and they're requiring waivers of liability, and I think that's pretty common for that industry. So, you might not want to be the only one who's requiring a waiver in your industry. So employees at high risk, this is a really complicated and urgent topic. And of course, the CDC has said that there are the people that are at particularly high risk for severe illness from COVID are those 65 and older, those who live in a nursing home, people of all ages with underlying medical conditions, especially if they're not well controlled, people with chronic lung disease, moderate to severe asthma, people who have heart conditions, people who are immunocompromised, people with severe obesity, and people with diabetes, chronic kidney disease undergoing dialysis, and liver disease. So let's talk about each of these categories in turn, okay? So employees who are at higher risk due to underlying medical conditions. Employees might be disabled under the Americans with Disabilities Act or the ADA and entitled to reasonable accommodations. Reasonable accommodations may include things like telework. They may also include other types of accommodations to the workplace to make it more safe. So you as the employer have an obligation to engage in what's called the interactive process with your employee, which is a back and forth dialogue about what it is they need. You never need to provide an accommodation. An accommodation is not reasonable if it eliminates the essential functions of a position. So you don't have to hire another person to do someone's job. You don't have to remove functions that are critical to a position, but you do have to see if there are things that you can do to accommodate your employees' health conditions. And we are in a particularly bizarre time where, for example, let's say somebody has diabetes and they've never needed an accommodation. Well, all of a sudden, because of this pandemic, they might need an accommodation to keep them safe. So you can't refuse to bring employees back based on their age or pregnancy or any other protected characteristic. So employees who are at higher risk might be eligible for FFCRA leave. So let's go through that a little bit. If you don't know, there was a new law that was passed that was effective April 1st that requires employers fewer than 500 to provide paid sick leave that is different than your Maryland Healthy Family sick leave and paid FMLA. And that applies to employers even if you are smaller than 50, unlike traditional FMLA. Because of the time constraints of this presentation, I can really only give you a high-level discussion of FFCRA. If you have other questions and believe me, it is it is definitely an important law to be aware of. My firm has done a lot of publications on this topic that are available on our website. You can always email me directly, but I'd really encourage you to go there. And the Department of Labor has an excellent FAQ that they have on this law that answers, really just about every question I can think of. So this law took effect on April 1st, and it sunsets the end of this year. And you are required to provide paid sick leave up to 80 hours of paid sick leave for in certain situations, which are listed on the next slide. So I'll read them out. But payments that you make are recovered through tax credits. Okay. So, when employers hear about this, they think, oh my gosh, I'm going to have to spend all this money. Well, it's only for employers that are smaller than 500. And I'm assuming that's because Congress wanted employees to get this leave, but then you're small, so you're not required to really, you pay it, you front it, but you get it back through your tax credits. Okay. So this paid sick leave is up to 80 hours and it is capped. So for the employee's own use of this paid sick leave, it is capped at the employee's regular rate of pay, capped at $511 a day. If the employee cannot work because the employee is quarantined, if a healthcare provider advised an employee to self-quarantine, so that would be for, let's say, a medical condition, so going back to diabetes, the provider says you can't go back to the physical office, or the employee is experiencing COVID-19 symptoms and is seeking a diagnosis, okay? Then there's a different category of paid sick leave that is paid at 2/3 of the pay, capped at $200 a day. And that is leave for the employee to care for an individual subject to quarantine or to care for a child whose school or child care provider is closed. There is an exemption, and I think this is probably of particular interest to a lot of you on this call. There is a small business exemption where if you have fewer than 50 employees, you can be exempt from providing the paid sick leave and the paid FMLA, which is, I didn't even get it. Well, the FMLA is for caregiving for employees who have children whose school or child care provider is closed. And it's 2/3 pay, capped at $200 a day for 10 weeks. So the exemption is available for people with fewer than 50 employees, but just for the care of a child for the paid sick leave or the care of a child for the FMLA. And there are certain showings that you have to meet to claim this exemption. You can't just say, well, I'm fewer than 50, so I don't have to do it. The Department of Labor has articulated specific criteria that you must show, okay? Okay, we covered that. And this is the only, for those of you that are already giving FMLA, if you're over 50, if you have FMLA, this is the only FMLA that is paid. It is very different than the typical FMLA, which is unpaid. Okay, so in addition to things like telework, these are some other accommodations that might reduce the risk. And you can, and you should, work with an employee to get this information. You're entitled to get information from a medical provider about the condition, about possible accommodations. These are all accommodations that you can think of. That could be options. Leave, unpaid leave is also an accommodation. Okay, so age. Age has been, I would say, particularly vexing with this pandemic because employees over 65 are more vulnerable, but there are no laws, unlike the disability laws, there are no laws here that require accommodation based on age. So what are employers supposed to do? Well, you may not involuntarily exclude people because of their age, and you may decide that you're going to extend some sort of accommodation or a benefit to your older workers right now. That's permissible. You just have to be clear that you're not doing it in a way that would give rise to other types of discrimination claims. But the EEOC has said, you may do things for your over 65 workers that you don't do for your 40 to 64 workers. Also, these workers may be eligible for FFCRA leave if their doctors are saying that they should stay out of the workforce. Again, that's only 80 hours. Okay. There are employees who are at higher risk. They may not, for pregnancy, may not involuntarily exclude pregnant employees from the workplace. Employees may have ADA, pregnancy-related conditions may rise to the level of an ADA condition, like preeclampsia, for example, gestational diabetes. So you must provide job modifications or leave to pregnant employees if they're provided to others. Again, FFCRA leave could apply here. Employees with higher risk family members. This is a harder one because there's no obligation to accommodate a family member's disability. The accommodation requirements only apply to the employee, him or herself. So you might choose to do so, but you need to be consistent in what you do. Okay, employees with caregiving responsibilities. I really think everyone needs to start thinking about what they're going to do with their employees who have caregiving responsibilities, because schools, I do not believe, will be going back in any sort of normal fashion in the fall. So this problem is not going away. You, of course, have the FFCRA, the FMLA. So taking those together, that can be up to 12 weeks of, partially paid leave for your employees. So that's one option. But, I really encourage people to think about, what else can you do? Can you do some sort of telework, et cetera? And for EFMLA, employees are only eligible for this if the child's place of care is closed or their school. It's not available in the summer because school is always closed in the summer, but it can be available if the camp closed, if the employee was planning to send their child to a camp and it's closed, or daycare is closed still. Okay, employee refusal to work. What happens if the employee says, I am not going to go back to work? I don't think it's safe. What can you do? So, you should minimize or address their concerns by telling them exactly what you've done to keep them safe. But a generalized refusal to work is not, you can't stay out of the workplace for that. There are lots of things you could stay out of the workplace for, but not just because you're generally afraid. And even for unemployment, there's, of course, been enhanced unemployment through the CARES Act. Employees are not eligible for unemployment because of mere generalized fears. An employee's refusal to work, however, could be protected under OSHA when all of the following conditions are met. If they've asked you to eliminate the danger and you failed to do so, the employee refused to work in good faith, so a genuine belief that imminent danger exists, a reasonable person would agree that there's a real danger of death or serious injury, and there isn't enough time due to the urgency of the hazard to get it corrected. Other things that can arise with refusal to work is something called protected concerted activity, which is under a different law, which is the National Labor Relations Act, which is usually people think of that in the context of unionized employers, which is correct. But the NLRA does have provisions that apply to all workplaces. And if employees can be engaged in protected concerted activity when multiple employees share a common concern. So you need to be careful about that. Of course, if anybody blows the whistle or, reports to a state agency, working conditions are unsafe, that would trigger some whistleblowing protections. So we've talked a lot about coming back to work and what you do when you go back to work, and having, you know, your various plans for your screenings and your temperature checks. But a lot of employees are also realizing that they either need to do furloughs or layoffs. So what is a furlough? A furlough is a time off of work without pay, and it's typically for a defined period. And the employee will stay on payroll and remain eligible for benefits. So most of the insurance carriers are allowing employees to continue benefits even if they're not working. So typically you would have to be working to remain eligible, but in the pandemic, there have been certain allowances. And furloughs can be full weeks or days per week. It really just depends. You know, if it's a full week, that can trigger unemployment compensation. Sometimes even partial reduction in hours can trigger unemployment, depending on what the salary is or what the paycheck is. A layoff is really a separation of employment. So that would trigger unemployment. You would need to give their final pay, pay out vacation, terminate benefits. One thought, just an FLSA consideration for exempt workers, you need to be thoughtful when you reduce their pay. So you can require the use of PTO, but because exemption is done on a salary basis test for most of them, you know, you want to make sure that if you're dipping below the salary basis, that has an impact. You know, you need to be thoughtful. You can convert people to hourly, but then you lose the exemption. You don't want to bounce back and forth between exempt or non-exempt. And in Maryland, you have to provide 1 pay period's notice of any change to wages. Okay, a reduction in force is really a term of art. It's when you reduce a large portion of your workforce, and you want to make sure that you're conducting that in a legitimate, non-discriminatory way. So you want to set your criteria for the RIF and then select who's going to be eliminated. And then typically what I would do with my clients is we go through a disparate impact analysis, and we look at, okay, you're letting go 5 people. You're letting go the only female in this department, you know, who's more tenured than this other person. Why is that? And, you know, you just want to make sure that everything is legitimate and defensible. So you would terminate benefits as well at this time. Some employers like to offer severance pay as well as severance agreements, which can be a release of claims that can give you some comfort that your employees are releasing their claims. Then COBRA, and you're going to get all these slides, you'll see these details, but there have been extensions through legislation on the time period to elect continuation of coverage. There's, we're still in the outbreak period, so you have extra time for notice. It's not clear exactly how long that is going to be. And, you know, employees have an extension of time to elect the coverage as well. Okay, so that concludes my substantive presentation. These are many resource documents for you with links. I hope that they're going to be very helpful for you. This will be issued to you, and, you know, as always, you can call me or email me with questions. And I think Kylie's going to help facilitate some of the questions that have popped in.
Thank you so much, Lindsey. And I know we're a bit tight on time, but we'll try to get many of them answered. There are a lot of questions regarding pre-existing conditions, as well as even conditions that have resulted as a result of the pandemic. So for instance, one question was asked about an employee who has developed panic attacks as a result of his fear of contracting COVID-19 or having a pre-existing condition. Is that covered under the ADA or the refusal of work? Is that something that would be covered there?
Well, that's a really good question. So mental illnesses, of course, can be disabilities under the ADA, and even mental illnesses that are new as a result of the pandemic. If they're, the hallmark test of a disability is if it substantially impacts a major life activity. And I think in that situation, it certainly could. So what I do with my clients is we have, forms that they would give to their employee. Their employee would give it to their doctor to get information. Then the doctor sends it back so that you can understand the employee's limitations and accommodations that you can provide. We've been getting a lot of questions about, what if somebody's doctor says that they need to work remotely for the rest of the pandemic? Mm-hmm. And the answer is it really depends. I can't sit here and give a blanket answer because it depends on the work environment and it depends on the job that somebody is performing. So if you are, if you're a cashier at a gas station, you can't work remotely. I mean, you just can't. So it's really going to be a fact-specific inquiry. And you're also entitled to look and see, are there other accommodations that could be provided that is not the requested accommodation? Employees are not entitled to the requested accommodation if there's another one that's equally effective.
Thank you. Another question was around if a company has fewer than 50 employees in Maryland, but over 500 nationwide, would that be classified as a large or small business under these requirements?
So for purposes of the FFCRA, they're going to look at your workforce across the country. So if you're above 500, then you would not be covered. But you don't count, if you have any employees on furlough that aren't working, those employees do not count in your employee headcount. So just bear that in mind.
Just to confirm, someone asked, I do not have to provide cloth masks for staff as a fast casual restaurant. That was the question.
So that's an interesting question because if you were in an office, I would say no. But because we're in Maryland and they are required by the executive order that, in the rest, I think that you should. I think that you should provide them.
Couple more questions, sure. If you have the time. So when staff decide to file unemployment, how does this affect the business in terms of keeping the company record? What do you have to maintain if the staff applies for unemployment? I think that was the question. Does that make sense?
I don't know. I don't know exactly what you mean in terms of records for people applying for unemployment. I mean, you have to, when somebody applies for unemployment, you will, of course, get paperwork asking if this person is in fact unemployed. We are seeing employees who, because right now you get, the max in Maryland is 430, but you can also get the 600 through July. So you might have a situation where an employee was asked to come back to work and they said, well, I'd rather get unemployment, or I can't come back because whatever reason, I have some reason. And actually some of those reasons will qualify you for unemployment. You can't just say, well, I'd rather not work and get $1,000 a week. The state agencies frown on that. But in terms of other record keeping, I'm not sure exactly what the question is about, but.
And is it legal to ask staff if they have an underlying condition?
So, I mean, it's a nuanced question. You would not say, hi, everybody, we're returning to work. Everybody with an underlying medical condition needs to let me know. You would not want to say that. But what you can do is, if you're preparing to return to work, you can send out some sort of communication that says, if anybody is anticipating difficulty returning to work, please contact me and let me know. And then you can discuss it with them at that point, because your obligations as an employer are different if somebody has a disability that triggers a certain law versus if somebody's over 65, which, as we talked about, is not really legally protected for accommodation purposes, but you as the employer may decide that you think it's the right thing to do and you're able to do something for those people. So you need to know, why they're not coming back, so you can know what your legal obligations are.
Well, thank you so much, Lindsey. I think you've covered most of the questions. Any other final comments you want to share?
No, thank you all for having me, and it speaks volumes about you that you're attending this presentation and you're trying to be as informed as you can, and have a smooth return to work process that keeps your employees safe. So thank you again, and please don't hesitate to reach out with any other questions.
Thank you.
Thank you.
Back to you, Alicia.
Again, want to thank you, Lindsey. As Lindsey mentioned, we went to law school together. It's always a pleasure to be with somebody who I learned beside this season doing so well. So thank you for doing this, Lindsey. And I'm sure we will have you back for another opportunity if you'd be so kind to do so.
Great.
Excellent job.
Thank you.
And with that, I'd like to introduce another law school family member, Amy Petkovsek. She is the Director of Advocacy and Training in Pro Bono for the Maryland Legal Aid. She is going to discuss important tenant rights and other topics. Amy, it is always a pleasure to have you with us, and we look forward to your insight.
Thank you, Alicia. Always great to be here. And I know we are running a little short on time, but don't worry, I will cover everything that we had planned. You just share my screen. And all right, great. So I just want to let you know, of course, this information that I'm going to talk about is current as of today. I updated it this morning because there were a few things that changed. Some of the information I'm giving changes depending on where your small business is, if it's in Baltimore City or if it's in Montgomery County. And so you can certainly reach out to us at our community lawyering team. We will answer questions for small business owners. And so I wanted to let you know that.
Amy, I apologize for interrupting you. Right now, we can see your presenting slides. You can just change your display settings, or I can share my screen with your slides.
Oh, sure, no problem. Is that good?
Perfect.
Got it. Thanks. No problem. To let you know that for Maryland courts, most hearings are canceled through June 8th, which of course is already passed. There are emergency hearings taking place. Courts are generally not accepting non-emergency paper filings. But on July 20th, which is coming closer and closer, in-person hearings are starting again. And we're going to talk about what that means for eviction and for tenants and for landlords in a moment. By October is when the courts hope to be back to full-scale operations. Of course, as you and I know, that could change as the pandemic situation changes. This is a list. I'm not going to read down through the whole list for the sake of time, but you can see there's a number of court hearings in person that are definitely still taking place. Most of that does not deal with property rights. It mostly deals with significant possible injury to persons, such as domestic violence hearings, peace orders, protective orders, guardianship, restraining orders, and then there's a lot of criminal things, related issues that are still happening as well for criminal law, like habeas corpus, criminal competency, matters involving incarcerated defendants. If there's a COVID outbreak in an incarcerated population, there may be petitions to be released, and those are being heard right now. just additional things on this list here, including many other protective order, body attachment, bench warrant type situations. So this is what many people think. I have an emergency. I want to be heard by the court, but this is what the court thinks is an emergency right now. And again, all of these lists that I'm showing you are what's being heard sort of right now until July 20th. And then after we get to July 20th, things are really going to pick up in terms of expansion of the topics of kind of issues that the court will be hearing. So, tenant rights. I have about 10 slides to go through, but this is my overview slide. Pay your rent if you can. So there was a erroneous message that sort of went out that said, you don't have to pay rent for, March, April, May, because we're in a pandemic. So that's not ever what was really said. What was said, and we'll go into it, is that if you could not pay your rent because your business was not open or because you were ill or caring for someone who was ill, that may be a defense later to not paying your rent. But if you can pay it, you should still pay it and will legally be obligated to still pay it. It just wasn't forgiven for that period of time. Evictions have been stayed generally and for now, and we'll get into what that means. But generally, you should not be forced out of a property right now, even if you have not paid the rent since February, March. If you're illegally locked out, you would call the police, your local law enforcement, and you have a few other actions you could take, and I will get into those as well. I will say I know I'm speaking to mostly an audience of small business owners right now. What I'm going to say applies to whether the same if you're a tenant as a small business owner or with your own property, or if you know someone who could use our assistance. So whatever type of tenant you are, in your personal home or your personal residence or in your small business, the same laws apply that I'm about to explain. So for evictions in Maryland courts, some jurisdictions, meaning some counties, started having emergency evictions on June 5th. For example, open warrants for eviction started then. I know that my colleague has a number of cases in Baltimore County and Towson that are scheduled, so those are happening right now. All other evictions, foreclosures are paused until July 25th, and new failure to pay rent cases will not start until August 31st. So there's a number of different ways that a landlord could try and legally evict someone, right? So that right now there's no illegal lockouts. But legally, there's tenant holding over actions, there's failure to pay rent actions, and those are going to start at different times. So someone might say, in fact, I had someone ask me at an outreach this morning, what's an emergency eviction case? And so, we just defended an emergency eviction case because the tenant has a dog, and the landlord tried to get them evicted saying, the dog is causing a disruption, doing X, Y, Z, and we were able to prove the dog actually isn't doing any of that, and the person just hadn't paid their rent, and they were trying to find a way to evict them, and so that was not an emergency. But if they had proved that the dog had bitten 3 people and it was it was illegal under the lease, and so that may have been an emergency situation. So that's an example of what someone could try to consider an emergency to get on the court's docket, to get a judge to pay attention to you live and in person before July 25th or August 31st. I do see there are some questions. I will definitely address those at the end in case I'm going to answer your question on a later slide. All right, so for tenants' rights in Maryland, the governor of Maryland has ordered that tenants may have a defense related to COVID-19 in certain eviction actions for the duration of the emergency. So what does that mean? And so that means if that on August 31st, someone files against you, your landlord, a failure to pay your rent action, you may have a defense. And that is saying to the judge, Your Honor, I couldn't pay my rent. The city of Baltimore would not allow my small business to be open. I had absolutely no opportunity to make income during that time. And here's the documentation I have to prove that. And so that's what that means, is that you may have a defense because of that. Additionally, totally separate from the state of Maryland, the federal government has stopped landlords in certain properties from filing new eviction cases and charging fees related to non-payment of rent, and sometimes that can go beyond July 25th. So the federal laws and who that applies to and what kind of property that applies to may offer you some kind of protection. If you would like to, you can certainly reach out to legal aid, or I can give you a few other resources at the end of my presentation to seek legal advice about whether your specific property is covered under the federal law. So you need to know that the courts cannot issue a judgment of possession against you if you can show a loss of income due to COVID-19 or due to the state of emergency. So for example, maybe your small business was allowed to be open. You were in a place like, I don't know, Western Maryland, where you could open much sooner than Baltimore City. However, you got COVID and you're the owner of the business and you could not open it and you could not make provisions for opening under the conditions because you were trying to heal from the illness. That would also be a reason why you could fight this defense, fight the eviction. But you're going to want to show documentation. So if the reason is that you were sick, that you didn't have the income to pay rent, you're going to want a positive COVID test or attempts to go to the doctor or screenshots when your doctor wrote you back and said, I'm sorry, if it was back in March or April, we can't get you in right now. There's no tests. You don't qualify for a test because you're not over 65. Something that proves that you did that. If all you have is phone calls and nothing in writing, you're going to want to keep a log, like a journal almost, where you just write down, on April 3rd, I did this and this and this. And then on May 1st, I tried this. So that when we go to court, and hopefully you have a lawyer with you, but you go to court on September 20th, you're not thinking, I think on May 15th, I called the urgent care, and then just write it down now. Even if you need to go back now in your mind to March, it's going to be better now on June 20th or whatever than it is going to be when we go to court in the fall. So you're going to want to show documentation. This is all new. Like, I've never gone to court or supervised an attorney going to court who tries to raise the COVID defense to eviction. That's new. So it's not clear how much evidence will be needed or when the cases will be heard. We do have an indication from other states that there will be a lot of eviction cases filed. So evictions can be filed right now, for example, in Richmond, Virginia, since May, and there's 2,200 cases pending on the docket. And I also heard on a national webinar yesterday that in Tennessee, where evictions are also being filed right now for failure to pay rent, there are 2/3 as many cases as there were at this time last year. So the pandemic has created a situation where the amount of money people have and the amount of disposable income they have to pay their bills, the distance between that is really shrinking. And so the courts are going to be overflowing with people trying to raise this defense. So the more documentation you will have, the better. All right, I want to speak to illegal lockouts. If you are a tenant, and again, this is whether you're a tenant as a small business owner or a tenant in your own property, and if you're a victim of an illegal lockout or an illegal eviction in Baltimore City, you can visit the court commissioner's office and you can press criminal charges. That's not the case everywhere, but that is the case in Baltimore City. And I've listed the information for that, the address and the telephone number on the slide. No matter where you are, though, during an illegal lockout, if you've incurred expenses because of that, you want to keep track. If you had to stay in a hotel, whatever your expenses were. We are representing 2 individuals right now who were victims of illegal lockouts very recently in Bowie, Maryland, and Prince George's County. And all of their belongings were put on the front lawn. We had them take pictures of everything. There's a video of children crying in the background. I mean, you want as much as you can document. That's really going to help. Whichever angle your attorney or you, under the guidance of self-help, are going to take to try and fight the case for an illegal lockout. Right now, you want to gather all that documentation because, again, I can't get you into court tomorrow because the courts are not in a phase of court where they're hearing lockouts right now. And so we have to try and find other angles right now to help clients. All right, regarding late fees and rent increases, we've heard from many clients, we thought there weren't supposed to be late fees. I did get my rent money together, but it was a month late, and now they're giving me a $70 late fee on top of what it was due. So locally in Maryland, jurisdictions have passed laws banning late fees during COVID. So that's right now Baltimore City, Montgomery County, and Howard County. other jurisdictions are considering them. They're in various stages of county commissioner land and town council land and things like that. So if you want to reach out about a fact-specific situation, we have lawyers that can assist you to navigate, because it does get very complicated what's been passed where, because it's a local ordinance situation. But late fees have been banned in many cases, as has been raising the rent. So, you know, it's an unfortunate situation to already be dealing with a pandemic, especially as a small business owner, and then find out my landlord raised my rent on top of that and raised it by a percentage that seems disproportional. So you want to be able to know if there's an ordinance in your jurisdiction that's stopping that. All right, a word to utilities. So your service cannot be terminated before July 1st is now what the Maryland law is about utilities, which of course is gas, electric, sewage, water, telephone, all of those things. And companies cannot charge you a late fee during the emergency for any of those things. Unfortunately, right now, unless again something changes, and it may change as it becomes a more emergent situation for individuals, which my colleagues and I anticipate that it may. But right now, your bills are going to be due after July 1st, and some people have not been able to pay their electric and their water bills since March. So instead of having to deal with a 1 month bill, you're going to have 4 or 5 months of bills to pay at once, because there was no forgiveness of those bills. Just they would not stop your service for that time period. So so stay tuned on that. But as it stands right now, you're going to have to pay your utilities. However, there should not be late fees for utilities. All right, there is some, and you may have heard this on the news, there has been some coverage of this recently in the past month, financial assistance to avoid eviction. There's some federal money, there's some money that's trickled down to the state governments and then to the city governments, and every jurisdiction is deciding what to do with that money differently and doing different things with it. But there are tenant assistance programs available in many jurisdictions, or they're like pending right now. And what that would mean is almost like a stimulus check from the federal government giving a tenant assistance to pay the rent so that they would not be evicted. So if you call 211 in Maryland, that's actually the easiest way to find up-to-date information on rental assistance. That's what we're advising people, because rental assistance is not necessarily a law. It's just an added benefit to individuals right now. Your attorney's office may not be the best place to find that information, as it is for the other things I've discussed. For this, it may be easier to look to a different public information source to find out what rental assistance programs are out there. All right, I just wanted to go over some general, if you called me today and were just a little bit worried about what might happen, tips that we might be giving to tenants. One of them is, if you think you can't pay, or you know you can't pay because you've had no income, try and work out a payment plan with your landlord now. Say, have the landlord agree, I won't file an eviction before December 31st. If every month you pay me 30%, then 40% the next month, and 50%, whatever it might be. But if you're going to do that, get it in writing, in an email, in a letter. It doesn't have to be like a formally executed contract, but you want to have whatever negotiations you're having with your landlord happen in writing, because we don't want to get to court later and have the landlord say, oh, I didn't say they could do that. They had to pay their rent in full, or I'm going to file to end their lease, and then a tenant holding over action. So you want to make sure that you're getting anything in writing. Again, I know I've said it a few times, but save all your documentation. If all you have is screenshots, that's fine. That we're going to be able to work with that as your attorney, but it's much better than a he said, she said kind of situation. You also can be proactive about the writing. Say your landlord's like, I'm not putting anything in writing. I'm smarter than that. Okay, but you proactively can write a letter to the landlord and explain why you cannot pay, and say, the city of Baltimore ordered all small businesses be closed until this date. We were allowed to open on, July 1st or June 1st. And then on June 10th, myself and my husband got COVID. And then we've been out for this long. And so we definitely don't have any money to pay the rent. You want to send that all in a written letter, send it to your landlord. And so that you can prove to the court in November, if you're being evicted, I failed to pay my rent, and I notified my landlord of this as soon as I was aware. So that can also, it's none of this is like, oh, then I don't have to worry. Unfortunately, I can't say that, but all of these things will help when an attorney represents you, or you represent yourself in one of these cases to try and prevail. Just a note about dangerous conditions. This is something that legal aid, where I work, does all the time, but some conditions have been really neglected during the pandemic situation. Whether that be, there's something hanging from your ceiling and it's about to come down, and the answer you've gotten since March is, well, we're in a pandemic, I can't help you now. So you want to place all complaints, documentation of the conditions, however many times you've asked for something. If it's a broken electric system, how many times have you asked for it to be fixed? You may be able to file for what's called rent to escrow, and that's when you put the money in an account that you would have paid for your rent with the court, so the money doesn't go to the landlord. You're proving that I could pay if my conditions were not dangerous, but since they are, I will pay the court account instead, and that will force my landlord to actually do something and fix this. You can request a housing inspection from your local government. That's 311 in Baltimore City, or call your local government office for housing inspections. Those were not really happening because people weren't going into people's homes during the earlier stages of COVID, but now they're starting to happen again. So that can help you. You don't have to do that, but that can help as well. And starting on July 25th is when Maryland courts are going to be hearing rent escrow cases. So that's soon. That's in like the next phase with the courts. So what's going to happen if you're thinking, well, I didn't pay and my landlord's not working with me, so when am I getting evicted? So once evictions resume, you're going to get notice of the court date. If you already were facing eviction, because we do have a number of individuals that were facing an eviction sort of before COVID, and they had a court date, say April 10th, but like that shut down when court shut down. So you've received notice of a new date. You may not receive notice again. So if you had like April 10th and you got a notice back earlier in the pandemic that said April 10th has been rescheduled to September 1st, you may not receive another notice. So you may need to call the court if you lost that, or you're not sure when your previous eviction hearing was rescheduled for. If it's a new filing, you'll receive initial notice of the court date. You want to bring all your documentation with you. If you can seek an attorney ahead of time, that is always, always helpful. Legal aid does provide free representation for those who qualify. And if you don't qualify, there are other groups that can help, such as civil justice. And that's a group that I would refer you to. And they pay on a sliding scale basis, and have a number of attorneys who may help with these cases. So you want to bring all your documentation to court with you. And then if there's an order for an eviction from the court, the sheriff will start executing those orders after July 25th or earlier if there's a court order. So not to induce panic, but that would be a court order from one of those emergencies that I talked about earlier. So if on July 1st you have a hearing scheduled for an emergency eviction, you would know about that and you would be seeking a lawyer or getting your documents together now. And there could be an order of an emergency eviction before July 25th. Otherwise, they would start happening after that time. All right, emergency paid sick leave. I'm not going to go into this in depth because my colleague Lindsey covered this. So I was just had a slide in there to sort of cover for you as a small business owner who's eligible, who's not, and make sure that it is on your radar. Because the new CARES Act allowed for additional paid sick leave that it did not before in Maryland. And those are just some details of who qualifies for taking those 80 hours of emergency paid sick time. A word about unemployment insurance, who can file for full-time workers, part-time workers, people who've lost their jobs, people who've been laid off or have had reduced hours due to COVID. We are getting, much like Lindsey indicated, a lot of questions now about employers that have employees who would rather stay on unemployment and stay home safe from any risk of COVID. And so that's not necessarily an option for them if you're offering them the opportunity to come back into the workplace. And this slide we left in just to highlight that under the pandemic unemployment insurance, which was the new part of unemployment insurance, gig workers, which is what they're called in the law, now qualifies. And the biggest group of those here is Uber drivers, Lyft drivers. People who did not qualify for unemployment before could now apply for that. During this whole pandemic time period, if you were receiving unemployment, you were not required to search for jobs, and that is still the case right now. A note about foreclosures. So if you are not a tenant, but if you are an owner of your small business property, however, you are also not able to pay the mortgage, because of all the reasons related to the shutdown and the pandemic. All proceedings related to residential properties were stayed. There was not a stay on business properties. However, if you can show as a small business owner that there's been an undue burden, you were closed, it may be a defense. Your biggest piece of advice is to get an attorney and to start fighting it earlier rather than later in the foreclosure proceedings if those are being taken against you. Also, you may be eligible for mortgage relief from the Federal Housing Finance Agency. And this is additional federal protections, some of which I spoke to earlier. And if your mortgage loan is owned by Fannie Mae or Freddie Mac, and so you may be able to seek mortgage relief in that way. Just a word about stimulus checks, because although we are not seeing as many calls as we were about round one, there may be a round two. It's yet to be determined, but in case there are, make sure that you and your employees are getting any stimulus checks that you're entitled to. If you filed a tax return, even if you only got SSI or SSDI, that's Social Security income, you're still eligible. And green card residents are also eligible. Someone who is claimed as a dependent, even if they are no longer a dependent, will not get a stimulus check as long as they were claimed on the previous taxes. So if the last taxes that were filed were for the year 2018, because you haven't filed for 2019 yet, because that's not due till July 15th, and there was an 18-year-old at the time who was 17 and a dependent in 2018, then that person would not receive a stimulus check in 2020, even though they're older now. So this we've had a lot of questions on whether or not your stimulus check can be garnished. So if there's a judgment in state court, you could file a motion to exempt your bank account so that it's not garnished. If you owe money to the bank, they can take it if it goes to direct deposit. Child support can take it just like they can take any taxed refund. But if you owe the IRS money, they cannot take it. So just sort of a quick down and dirty on what they can take and what they can't in terms of that. A word that we're slipping in all of our presentations right now about fraud. Fraud is on the rise right now, and you as small business owners are probably very savvy to this. But just make sure that your employees are aware that phishing schemes, malware schemes, anything with technology is out of control right now, very rampant. And on top of everything else, when you're worried about employment laws and being evicted and paying your mortgage, you don't want to be worried about fraud as well. So you can always contact the Attorney General's office. There are a lot of individuals, mostly working from home, but working hard nonetheless, who are happy to advise Consumer Protection Bureau whether or not this is fraud, whether it's not fraud. Always check first before you buy anything, before you give your information to anyone. If you're even a little bit unsure, check first. All right, I made it to the time for questions. So in terms of seeking additional help, if I said something today and you want to know how it applies to your specific situation, you can start by reaching out to Maryland Legal Aid. That's where I work. We are able, depending on your financial situation as a small business owner right now, to help some individuals. If you do not financially qualify, because our services are free, if you don't financially qualify, we can then refer you to the best appropriate resource for your situation. It may be civil justice, it may be a pro bono or volunteer attorney, and we have some firms that we're working with that are helping small business owners. So we have, this is a specific phone line at Legal Aid, it's not the main number, and we've let our community lawyers know that small business owners might be calling and where to refer them if we cannot provide them with the assistance. So with that, I will close that and answer questions.
Thank you so much, Amy, for all of the information you just shared. I'm sure many of the small business owners are energized by learning about what their rights are and the opportunities that have been made available. One question was related to landlords ensuring clean common spaces. How can you make sure that your landlord actually maintains these common spaces, and in particular, a public bathroom, let's say, in an office building?
Interesting. I took that slide out because I was like, I don't know if they're going to have questions about that. That's funny. Yes, you should be ensuring, because your employees have to walk through that space, right? And often you may be 3 small businesses in one building that are all sharing the same bathroom. Absolutely. So you have every right to ask what their protocol is. what their cleaning protocol is, if that has changed, if they used to clean with a janitor service once a day, if they've increased it to twice a day in the bathroom areas. So they can't withhold that information from you. And then if you feel that what they're doing is not safe enough, it could fall under a dangerous condition that would then fall into rent escrow and all those things that I talked about ways that you can withhold your rent if your conditions are not safe. Now, of course, many things Lindsey said, like we've not seen COVID before, so I don't know how this would play out in a court. But I would say, like, if they're not cleaning at all, that's dangerous right now, right? Like, that's pretty clear. If they're cleaning some, but not as much as you are in your own business and you wish it was more, that's going to get real gray. But lawyers like gray, right? So there's a lot of chances to argue then, but that's what I think about that.
Thank you, Amy. Another question related to, so right now it seems like in order for this particular person to get their security deposit back, should they no longer be able to pay and they just want to leave, it seems like they have to be present for an inspection and they have to get certified mail. And the question was, given the challenges around COVID-19 and people's desire to socially distance, can that still be required or enforced?
Right now, that is still being required or enforced. If you feel like, so for example, if you have like COPD and you're like, I'm not going to an in-person, I'm staying in my house so that I don't catch COVID and possibly die, you would file something with the court to say that, I want my security deposit back. These are all the efforts I took. I told them I can't leave my home. I can't go for an in-person inspection. This is why. And you would ask for a judge to resolve that for you. And that's probably going to be heard after July 25th.
Thank you. And I think you've already said this. It sounds like if someone were to change the locks on your business and you go to return, that would be...
They can't change the locks. They are changing the locks. I met with a client this morning at an outreach in Baltimore City where this happened. It's very upsetting to us right now who are respecting the laws and the moratoriums. And so if you're in Baltimore City, you want to call the court commissioner, and that's the information I gave in the slides. The slides, you can make the slides available, Kylie, to them. That's fine. Just know everyone, and it says on the slides too, that's the law as of today. And it certainly, if you distribute it, it could change even tomorrow. But they can't illegally lock you out right now, but they could. So you want to be upfront about communication. If it happens to you, you want to take pictures, you want to document everything, because there are things we can help you with on the back end. Even though that's a ton of stress and trauma, we can still try and recoup some of your losses.
And this is the last question, and I'm not sure, and if anyone else wants to ask a question, now is the time to ask Amy. But this is a question that you maybe is in your field of expertise or not, related to Chapter 5 bankruptcy. So if someone, as a result of everything going on, files Chapter 5 bankruptcy, will they be able to still, I guess, retain ownership of a mortgage related to their business, things like that? Like, will they be able to, I guess, maintain that ownership while still having the bankruptcy?
So I would need to know more about the individual, which I don't need to know right now because I can't answer your individual facts in front of everyone, but we would need to know more about the individual situation. Legal aid does do bankruptcies. And actually, we have a new partnership with the Maryland State Bar Association's bankruptcy bar to handle these types of cases. So those are volunteer attorneys at law firms that are working with us to provide extra bankruptcy help starting, I think we're launching July 1st because so many people need it right now and have questions just like that one. And so I would encourage you to reach out with that question because I know that's an area we're helping with. It, unfortunately, the answer is like, it depends because it depends on this and this and this and what your situation is. But if you have a lawyer, we're going to try and fight for you to retain what you want to retain. But sometimes bankruptcy is the only option. People think bankruptcy is different than what it actually means. So sometimes people are like, I give up, I have to file. And you don't always. You may be judgment proof. You may have different exceptions. And so it's really important to reach out about that. Even when I started learning bankruptcy law, it was much more complicated than I imagined. So I would reach out with those questions.
Thank you. And I'm just saying one question coming in, and this is the last one. Just came in. We'll leave it exactly at 2:30. Is asking around if the landlord has signs that requires everyone to wear masks, but then some of the residents or other tenants are not wearing their mask. What can you do? Can you do anything, I guess?
That is like the question of the day everywhere, right? Like, what if I go to Giant and they won't keep their masks on? So that's an unknown answer because it's unknown what the enforcement for non-mask wearing is, and it depends where you are. In some jurisdictions, mask wearing is more of a requirement than others in terms of there can be a penalty for not. If it's just a recommendation and the landlord has a sign up, we recommend masks. People are like, it's a recommendation, not a law. And if that's the stance they're taking, then the landlord may not be able to enforce that, which means you wouldn't have any action as a small business tenant against the landlord, unfortunately. So it may be a battle worth fighting if people are being blatantly disrespectful or really over the top relaxed about it and not following it, but it's going to probably be a hard battle to fight unless mask wearing becomes a regulation, a legal ordinance, like speeding on a highway.
Got it. Well, thank you so much, Amy, for your time. Thank you for all of our attendees for joining. Feel free to just lift your hand in the participant area to just give a round of applause to Amy and Lindsey and Alicia for their time today. Thank you again. And we will be following up with an email asking you for any other questions, sharing the slide deck and the contact information for Lindsey and Amy. Thank you so much.
Thank you, everyone. Bye.